your host, Donna Loring of Wabanaki Today. Welcome to part 3 of our show on the Penobscot Nation River case with our guest, Kirk Francis, Chief of the Penobscot Nation.
Well, I think what the court's trying to do here is make everybody happy. And what it does, it says, okay, we're going to recognize the sustenance fishery, but we're also going to recognize the concerns of the state about tribal authority. And you really can't have it both ways. The right either exists or it doesn't. And that's the only question we were asking. So the court does a bunch of things. It says, but the hunting, trapping, taking of wildlife, that only exists on the islands. So he separates those. So he separates the total package of the sustenance rights of the tribe. Then he says, then he gets into defining the reservation, which, according to the decision, appears to have severely shrunk. So what does that mean for us? It means that we don't know what to do with our 40-year-old State Academy trained game wardens. We don't know what to do about that, what this decision means in terms of their authority. And it's just created a whole other mess. Now our position is a recognized bank-to-bank authority over sustenance fishing comes with the associated authority. It makes no sense that a state government would be managing an Aboriginal fishing right. And so we're going to keep approaching things in that manner, but it's going to be a long, drawn-out legal process, I think.
Yeah. This the complaint here was about the summary judgment, motions for summary judgment, and it just said in part, they've was it this? Let me see. Before the court has 3 motions. And it goes, the state defendants, and then the tribe, and then the United States, and so explain about those 3 different motions, how that court reacted to those.
So you have the United States, the tribe, the state of Maine, and the interveners, right? All in this case. So what's interesting about the case is that our filings never changed. We amended our complaints to tweak language and those types of things, but we were asking the same question the whole time. We brought the suit. We brought it under a certain condition and for a certain purpose. The United States, so when summary judgment was filed, in the oral arguments later, the tribe stood up and said, the judge asked very straightforward, he said, are you claiming to own the river? And we said, no, we're not claiming to own the river. We're claiming basically that we have Aboriginal title that allows us to exercise an ancient sustenance-based right that also, for those purposes, is under our control. There's no other controversy. We're not here asking for a dam to be removed. We're not here asking for a pier to be removed. We're not here challenging people's property up and down the river. We're asking, in this geographical location, you respect the unique and distinct culture of the tribe and their associated responsibility to those activities. So the United States, however, stood up and said our position is they own everything. And that's it. Under the trust responsibility, this is Aboriginal title. They own bank to bank, and they get all the authority within. So, in terms of the sustenance rights, so the United States took a much stronger stance. Every argument they made got blown out of the water in this, no pun intended, in this decision. The judge really didn't answer any questions they raised in terms of there's got to be at least a riparian recognition and a sovereign authority to to the thread, at the very least, of the river. And that question never gets answered by the court. And so that's one of the clarifying questions they're asking. Then on the state side, you had them filing, basically saying and creating an atmosphere that the tribe was backdooring their way in through this sustenance-based right to control the river. Now, you have the Maine versus Johnson case, which is very clear on discharges and who regulates that. You have, and again, that was another decision that went above and beyond what was being asked of the court. They even took the on-reservation discharge site in that decision. So that issue had been settled and resolved. And so what we see in these court settings a lot of times is, and I don't deny that these are complicated issues and they're complex, but at the same time, I mean, what we often see is we're going to go as far as we can go to send the message that this does not mean the tribe has this kind of nation within a nation power. And so that's the concern with the case, is that we feel like our reservation, according to some of the language, could be taken to say that it's a third less than we ever understood it. Multi-generations of people understood it. And that the sustenance-based hunting, fishing, and trapping rights and authorities only exist on the islands, when it's been a historical understanding that existed throughout the entire river. You know, that it goes against multiple pieces of treaty. It goes against, we believe, is a total violation of the Settlement Act and what was promised to the tribes. And so, and what Congress promised. So we had a uphill battle here in terms of getting outcomes through the processes we talked about. But also, we got a long legal battle ahead of us to clarify a lot of the language. What's also very weird about the decision is, as I said, he quotes the canons of construction a few times within the, and those either apply to tribes or they don't. I don't think you get to say, well, over here, if it's ambiguous, then I got to go with the tribe. So at one point he says that the Settlement Act is so hard to understand that it's crazy and it has to be ambiguous, so the tribe wins here. But on the other side, he says the plain language of the Settlement Act, islands only, and no mention of water, is clear. And for me, it seems there'd be nothing more ambiguous than something not mentioned in the thing when that's the core of the fight. So to me, the fact that it wasn't talked about, it was never resolved. It was never seated. And so if you don't have a two-party discussion about water rights, and that's documented and there's language and all of that, this was a land claims, and it was about defining the land of the reservation. The island's only definition was meant to describe point A to point B in a certain geographical location, those islands. So I think that the ambiguity there was huge, and the canons should have applied there. Now, we have nothing, we have no evidence of the tribe ever ceding the Penobscot River, but yet we're going to determine that it's not theirs. So it's a little bit strange.
So that the decision in this particular judgment, it didn't give everybody exactly what they wanted. It left something, so they say, for the tribes, in that it maintained our sustenance. That was it.
Mm-hmm. And look, we're grateful that the court recognized the bank-to-bank authority. I think that that's huge for the tribe. I think, especially if the tribe decides to go to the next level, that it gives us that factual platform. I mean, that we didn't have. I mean, we have to remember the state's position in this case was, if you're standing on the island, you can fish. As far as you can cast a fishing pole
Yeah.
or whatever, you can fish. But you don't get to stand in the water and do it. Not 1 foot in the water. So getting that bank-to-bank recognition it is a win for the tribe. What we're talking about now, though, is why isn't that considered our territory, if that's the case? And why do we not get to manage that under the authority of the tribe? And why, if that sustenance right is defined in that geographical location, why are the rest of them not? So so it's a little bit it's just confusing, and I think our lawyers in the United States themselves are struggling to try to understand it. That's why they filed for the reconsideration, for clarity on a few of these issues.
For who to reconsider?
The judge.
This judge, the same judge.
So it's part of the process apparently, and
How often does the judge change his mind after reconsideration?
I don't think too often.
I don't either.
And so I don't hold a lot of faith that the court is going to deviate from their position. I mean, they may, hopefully they'll see, okay, yeah, we missed that, and we need to, that's not what we meant, and that's our hope. I think, though, it's going to be difficult for those reconsideration motions to succeed. I think that the judge has proven anything in this case. He's been fairly straightforward in terms of when he does make a decision. That's what I mean, we filed multiple motions to get the interveners out of the case, and we didn't feel that they really should have been there to begin with. And once he made that decision, he never really deviated from it. So I think I don't know,
decided to keep them in. Is that his?
Yeah. And I think it's just my personal opinion. I'm not an attorney, but I don't have a lot of faith that a lot comes out of a reconsideration motion. Maybe I'm wrong, and I hope I am, but I think our legal options are going to be at a different level.
So let's say that we proceed all the way to the Supreme Court. Of course, that decision hasn't been made or whatever, but I mean, what would be the next step beyond this level?
So it would go to the First Circuit Court of Appeals, where you'd get a panel of judges, and you submit a whole new brief based on why you think the court got it wrong, basically. And in an appeal, you're not allowed to present new evidence and all that kind of stuff. It's based on this case, and so really, as we continue to look through this, and when I say we, I mean the attorneys continue to look through this, we see more and more opportunity for those arguments to be made. And I think the tribe is really grappling with, as you know, I mean, and we've talked about, the tribe in these processes gets beat up a lot. And, so it's hard for us to get out of the mindset sometimes of what else are we going to lose. And, so I think, we're really grappling with a lot of things. This is a very, very important issue, and it's we had a council meeting the other day, and there were very few dry eyes in there when we were breaking this case down for them. And, people, the council's stressed out, leadership's stressed out, the membership is stressed out. I mean, we got kids and grandkids and future generations to protect on this issue, and for them not to have access to their ancestral waters is a devastating blow to the cultural growth of the tribe or maintaining our culture. So so it's a huge issue, maybe the biggest case in our lifetime, and hopefully, as we get through more of this process, we understand the legal kind of how this can be rectified legally, and you know, I just don't see our tribe, on another note, standing by and taking this. You know, I think that we have to we have a responsibility. I mean, it's not a matter of wanting to keep fighting and wanting to, I mean, really it's a responsibility we have to do. And so personally, as I sit here, and I'm not the only decision maker, I think we have to continue to make these arguments in every venue possible until we come to a place where we're protecting ourselves and we have the law behind us to do it. So that's kind of where I am.